Okay, so hello and a warm welcome to all. Welcome to Research Circle. I hope I am audible to all. So today we are gathered here for an exclusive webinar, which is titled as Laws on Judicial Appointments in India. And for this, we have with us our today's expert, Mr. Amit Kumar. He is a research scholar at Kurukshetra University and NET qualified. He did his BA LLB honors and LLM Constitutional and Administrative Law from Kurukshetra University, Kurukshetra. Formerly, he has worked as a law research at Punjab and Haryana High Court, Chandigarh. He is the author of the book titled Law on Passport in India. He has got many research papers published in various national and international journals. He has a keen interest in reading and writing law articles. So without wasting much time, let me welcome Mr. Amit Kumar.
Thank you so much, sir. A very good afternoon to one and all. I would like to thank the Research Circle team for inviting me as a resource person in this webinar. And also, I would like to thank the team and congratulate the team for creating this wonderful platform which help the researchers and academicians around the world to come together and share and learn new things. The topic of this webinar is laws on judicial appointment in India. So let us start. Well, there are three organs of government: legislature, executive, and judiciary. Each organ has its own importance. Legislature is there to legislate, executive is to execute, to implement, and judiciary is to interpret the law and to punish who are violating the laws. We have been witness of this fact that wherever there is controversy relating to the provisions of ordinary law or constitution, the judiciary has played its role fairly. The people of India have much faith on it. And in order to obtain this faith and respect, judiciary has to discharge its function fairly and wisely. Fair and quality judgments can be delivered only by competent judges. The competency of the judges will be ensured by good appointment process. There has been a big debate in India on judicial appointments. The criticism has occasionally been leveled that the selection has not been proper and has been induced by ulterior motives or consideration. There are also complaints of executive interference in the appointment of judges, and because of this concept of committed judiciary came into existence. The charges of favoritism has also been leveled against the appointment process. Wrong appointments affect the image of the courts and it undermines the confidence of the people in the court. Therefore, it makes necessary to understand the various methods of judicial appointments. First of all, let us analyze the various models for judicial appointments which are found throughout the world. But generally, there are four models of judicial appointment. First, by appointment by political institution. Second, appointment by judiciary itself. Third, appointment by judicial councils, which include non-judicial members. And fourth, appointment through an electoral system. So now let us discuss them in brief. First of all, appointment by political institution. So under this model, the judges are appointed by political institution, that is organ of the government, be it legislature, executive, judiciary, they all play a role in appointing the judges. So this model can further be divided into three categories. The first one is the representative system. Well, this system means that each of the several political institutions shall contain the percentage of the courts. For example, legislature would have a share in the judicial appointment, executive will also have a share, and the judiciary will also have a share in the composition of the judiciary. This system is followed in many European countries like Italy and also in Asian countries like South Korea, where the constitutional courts is formulated by 1/3 members appointed by the president, that is executive, 1/3 appointed by the legislature, and 1/3 appointed by the judiciary. Thus, under this organ, the system, we find that the representation of each organ of the government, and therefore the system is known as representative system. And the object of the system is that it focuses on collective nature of the court to ensure independence and accountability as it mixes different type of professionals of various political backgrounds in the court. The second category is of cooperative system. Here, when we talk about representative system, there were three organs that were participating, but in the cooperative system, we see that two political institutions that are working in the appointment process. Example of this system can be seen in USA, Brazil, Russia, where the judges of the Supreme Court or the constitutional courts are nominated by the president and approved by the House of Legislature by a majority vote. And the third category is domination of a single political institution. And here we will find that only one political institution is appointing the judges. And the classic example of it is the German constitutional courts, which are appointed by the parliament. So this was the first model. And in it, we saw that representation of the three organs, two organs and one organs. And in that way, we have categorized these models. Next, the second model is appointment by judiciary itself. Under this model, the judges are appointed by constituting the Judicial Council, and this Judicial Council is entirely comprised by the judges. Thus, here we find the judges are appointed by the judges, and only therefore this model is known as appointment of judges by judiciary itself. And the example of this model is India, where there exists a system of collegium where judges are appointed by judges themselves. Now, question arises why this model has been adopted. Well, the answer to it is that it helps in ensuring the judicial independence without any interference from any other organs of the government. But this model have also been criticized because there is a concept of accountability which is not followed. Because if judges are being appointed by the judges, there would be no fear or any pressure from outside which could have a negative impact. Because in India, the removal of the judges took place with help of the mechanism which is known as impeachment. And so far in the 73 years of inception of the constitution, not a single judge has been impeached, although various allegations has been leveled against a number of judges. So that is the criticism of this model. Next model is appointment by Judicial Council, which include non-judicial members. The third model is appointed, in this third model, the appointment by council, which is comprised by judicial as well as non-judicial members. This council is a body which which perform various functions, be it appointment, promotion, and the discipline of the judges. It is one of the most popular model of judicial appointment, and roughly around 60% of the world countries had adopted this model, including countries like Iraq and US, where there are judicial councils. And in US, we see that out of 50 states, majority of the states have this model, where the judicial councils are known as merit commissions, which nominate judges for appointment. Now let us discuss the composition of merit commissions. It can be comprised of the judges from the various level of court, members of the government bodies, members of bar association, and laymen or common men. Now talking about the fourth model, that is appointment of judges by election process. And this model is adopted by certain states in US, and this model gained popularity in the 19th century to enhance the accountability of judiciary because of the fear that the judges were elitist. So therefore, this election process was introduced in certain states. So these were the four models which we have found around the world. Now let us discuss about the judicial appointment process around the countries. We will talk about certain specific countries now. First of all, let us discuss about position in United Kingdom. Here, before the Constitutional Reforms Act of 2005, there used to be a House of Lords, which used to be the final judicial authority, and the House of Lords members were appointed by Crown, acting on the advice of the Prime Minister. But after the 2005 reforms, the situation has changed. Now they have a Supreme Court in place of House of Lords, and judges are appointed by special selection commissions and by the JAC, that is Judicial Appointment Commissions. So system has changed there after 2005 reforms. Next, in Australia, it is a part of British Commonwealth. So there, the appointment is done by the Parliament, appointed by Governor General in Council. And similarly, in Canada also, it is also part of the Commonwealth. So they follow the same system where the judges are appointed by Governor General in Council. Now, talking about position in USA. So in before talking about USA, let me tell you the political system that exists in USA. So in USA, there are 50 states. All of them have their own individual constitution, and apart from that, at the national level, a union level, they have a different constitution. So, and each constitution prescribe different ways for appointing the judges. So first of all, let us, if now we discuss about the appointment of judges of Supreme Court of USA. There the judges are selected by the president, and which is required to be approved by the Senate. But in some states, judges, as we have discussed earlier also, that they are elected through election process. And in certain states, there are nomination by merit commissions. Now let us talk about position in France. In France, the judges are appointed by the head of the state, with a high-powered committee which recommends and advises the head of the state as to who is to be appointed as the judge of the superior court. Now, let us discuss about Japan. In Japan, the Supreme Court members or the judges are appointed by the cabinet, except for the Chief Justice, who is formally appointed by Emperor after nomination made by the cabinet. So now we move to next part, that is the appointment process in India. But before that, we need to understand the hierarchy of courts and the historical perspective, how courts have evolved in India. Well, the history of judicial administration begins in India with the enactment of High Courts Act by 1860. We were under the British rule at that time, and High Court Act of 1860 was enacted, which set up high courts at various provinces. And from there, appeal used to go to Privy Council in England. But in 1935, there was change in the hierarchy, and British Parliament enacted the Government of India in 1935. And under Section 200 of this Act, it created a federal court at New Delhi. So now appeals from High Court goes to federal court, and after that, it went to the Privy Council at London. But as in 1947, when we got our independence, there was change in the system. First of all, in 1949, there was abolition of Privy Council, because we cannot have because at that time Privy Council was situated in England, and because of our own sovereignty, we couldn't ask our cases to be decided by some other sovereign. So therefore, this Privy Council was abolished. Its jurisdiction was abolished in 1949, and on 26 January 1950, the day on which we celebrate our Republic Day, our Constitution came into, and under the Constitution, Article 136, Supreme Court was established, which removed the federal court, and in place of federal court, now we have Supreme Courts. So before we go through the Supreme Court, let us now understand the hierarchy of judiciary that exists in the present time. So we have a three-tier judicial system in India. First of all, there is a lower judiciary, then there are high courts, and after that, Supreme Court. The lower judiciary, the judges are appointed by written examination, which are conducted by the respective high court under whose jurisdiction it works. And for High Court and Supreme Court, the provisions are made by the Constitution, which we will discuss now. So before we discuss about the appointment process, let us discuss about the Supreme Court's jurisdiction. Well, Supreme Court has three types of jurisdiction in India. One is original jurisdiction, second is appellate jurisdiction, and third is special jurisdiction. So original jurisdiction means all the matters which can directly go to the Supreme Court. For example, when there is dispute between two states, so then the appeal goes directly to the Supreme Court. Second, when we talk about appellate jurisdiction of the Supreme Court, here the appeals, be it civil case or in civil case or criminal case or constitutional case or constitutional matters, the appeal goes to the Supreme Court from High Court. And the third is the special powers under Article 136, where the Supreme Court has unlimited power to entertain any appeal, because there are certain matters for which no provision is made for appeal to the Supreme Court, but Supreme Court on a leave application, special leave application or special leave petition can decide and admit the appeals. So these are the three jurisdictions that Supreme Court have. But however, there are certain limitations on Supreme Court powers to directly deal with an appeal. For example, when there is an order from tribunal, it will first go to High Court, and after that, it will go to Supreme Court. Similarly, when it pertains to a matter relating to army, there are those tribunals which have the jurisdiction over those matters. After that, the appeal goes to High Court and then to Supreme Court. Now, let us discuss about the appointment provisions in the Constitution for Supreme Court judges. So Article 124 clause 2 and 3 are very relevant in this regard, where Article 2 deals with procedure of appointment and Article 3 lays down the qualification for being a judge at the Supreme Court of India. So now let us read the bare provision that is provided under the bare act of our Constitution. That is, every judge of a Supreme Court shall be appointed by the President by the warrant under his hand and seal after consultation with such of the judges of the Supreme Court and of the High Courts in the state as the President may deem necessary for the purpose to hold office until he attains the age of 65 years, provided that in case of appointment of a judge other than the Chief Justice of India shall always be consulted. So thus, there is express power to appoint judges is conferred upon the President of India. And if we see the proviso, we will find that it imposes the obligation upon the President to consult Chief Justice in case of appointment of other judges. Well, before we go to the appointment process, let us go to history and how judges used to be appointed by under the British rule. And if we see the Government of India in 1935, which established the Federal Court, we will see that under it, the provision for High Courts judges' appointment was the prerogative of the Crown, with no specific provision for consulting the Chief Justice in the appointment process. But when our Constitution was being drafted, there was a debate on the consultation process, and the Constitutional Assembly ensured that no appointment could be made without consulting the Chief Justice of India. So we see that there is now a provision that Supreme Court the Chief Justice of the Supreme Court has to be consulted. However, if we see that the judicial appointment process, it has been under scrutiny of the courts themselves. And if we see the period, we can divide that it can be divided into two heads. There was an era where there was executive supremacy in the judicial appointment, and after that, there was judicial supremacy in the appointment process. So first of all, let us discuss about the period when there was executive supremacy. Well, let us understand what executive supremacy means. It means that President will be under no obligation to consult the Chief Justice of India, but if he deems necessary to consult for the purpose, only that situation he may consult the Chief Justice of India. So now let me talk about the landmark cases. There are certain landmark cases regarding the judicial appointments. Then the first case is Union of India versus Sankal Chand Himmatlal Seth. This is a Supreme Court judgment where the court held that the word consultation means full and effective consultation, but President, however, has a right to differ from them and take a contrary view. Therefore, consultation does not mean concurrence, and the President is not bound by it. And it was followed by a case, it was followed by SP Gupta versus Union of India, the Supreme Court unanimously agreed with the meaning of the term consultation as explained by the court in Sakal Chand case, and the court rightly observed the meaning of the term consultation under Article 124 clause 2 is the same as the meaning of word consultation in Article 217 and Article 222 of the Constitution of India. And the only ground on which the decision of the government can be challenged is that based on malified grounds. So thus, after analyzing these two judgments and two decisions, we can say that the President, that is executive, had supremacy in appointment of judges, because it is his domain if he want to consult the Chief Justice or not. And even if he consult, he's not bound by the decision of the Supreme Court or the Chief Justice of the Supreme Court. Now, there was a change in the view of the court, and in 1993 we can say that there was a shift of the paradigm, and now there's a judicial supremacy since 1993. After 1993, Supreme Court adopted another view on appointment of judges, in which it was held that judiciary has supremacy in appointment process and in order to maintain judicial independence. In Supreme Court on Advocates on Record versus Union of India, 1993 Supreme Court judgment, the 9-judge bench overruled its earlier decision and laid down guidelines for judicial appointment. First, let us read the guidelines. The first was that the process of appointment of judges of High Court must be initiated by the Chief Justice of respective High Court. Second, the proposal of Chief Justice of High Court must be sent to all other constitutional functionaries, that is state, and within 6 months must convey its view to the Chief Justice of India. After considering the recommendation of the functionaries, the Chief Justice of India should confirm his final opinion and convey it to the President within 4 weeks of the final the person is close to the Chief Justice of India and option is valid, candidate should not be appointed, but objection must lead to character, conduct, health, or other factor. Although this judgment is very confusing, but we can say that there's a shift in the Supreme Court, and now the primacy is given to the view of the judges. Now, there's next also another important case, that is the reference case of 1998, where Supreme Court laid down certain guidelines, which can be summarized as that consultation with Chief Justice of India does not mean consultation only with the Chief Justice, rather it requires the consultation with plurality of judges. So now it has even overridden what is written in the Constitution, and because in Constitution we will see that only Chief Justice is mentioned, but now after this judgment says that it does not only mean Chief Justice, rather it means consultation with the plurality of the judges, that is collegium. The collegium shall consist of the Chief Justice of India, who has to formulate the collegium of 4 senior-most judges of Supreme Court for appointment of judges in Supreme Court and for the transfer of judges and Chief Justice of High Courts. Second, for appointment of High Court judges, the Chief Justice has to consult 2 senior-most judges of the Supreme Court, and the collegium can also take into account the views of Supreme Court judge from a particular High Court to which appointments are to be made. Fourth, the opinion of the collegium should be given primacy. The members of the collegium should be given in writing and forwarded to the Government of India along with the recommendation of the Chief Justice, and mostly that merit is predominant, but senior is judicial independence. Now, there are certain recent developments that has happened, because when the consent of collegium was adopted by Indian judiciary to appoint judges of High Court and Supreme Court, and subsequently Indian Parliament brought this amendment of Constitution inserted certain articles. They are in the Article 4 makes provision for the establishment of national judicial appointment. So when we read discuss models, so this national judicial appointment commission, it's that it should there 24 said that there shall be a commission to be known as National Judicial Appointment, consisting of the Chief Justice of India as the chairperson, 2 seniors of the Supreme Court, Law Minister as a member, and 2 other members nominated by the committee. Position, in case there is no leader of opposition, the leader of the single largest opposition party in Lok Sabha. Then there were Article 124 followed what would be the function of the commission, 124C about the power of the parliament to make laws. And in exercise of parliament further enacted another law, that is National Judicial Appointment Commission Act of 2014, This law basically contained the procedural aspect to give effect to the 19th Constitutional Amendment. Well, the 19th Constitutional Amendment Act was challenged because this amendment was criticized by various scholars on the ground that it was against the principle of judicial independence because executive has been given equal role to appoint the judges. Nowadays, we find that government is the litigant for the court, and if goes appointment process, it definitely hampers quality judge because a judge who has executed this appointment process, he will have a certain of the court association in 2015 this then be constitutional and void. Am I audible?
Yes, sir. Your connection is bit low.
I have some problem with the Wi-Fi. Let me read. We will see it. So this amendment was changed, and the bench in 421 rejected the NJS and the 19th amendment as a branch of the Constitution, that is judicial independence. It is also against the principle of separation of judiciary from executive contained under Article 50 of the Constitution. Judiciary has adopted now the second model appointment, that is judiciary, the judges being appointed by the judges themselves through collegium. But the court accepted that there are certain loopholes in the collegium forms in true sense. So in conclusion, I would like to say that at present, judiciary is playing a pivotal role, an important role in interpreting and applying the laws. And Indian Supreme Court is treated in India as the guardian of the Constitution because of the essence of the federal Constitution is the division of powers between union and state. And this division is made by written Constitution in which Supreme Court, which is the supreme law of the land. And in order to maintain the supremacy of the Constitution, there must be an independent and strong judiciary to decide dispute and to remove ambiguity. But unfortunately, there are incidents which raises question to the credibility of judiciary. But when about the judicial appointment process, then we can see that there is no other country in the world where judges are appointed by judges themselves except in India. Thank you.
Thank you so much for your valuable guidance, sir. We try to provide the email, put an email ID in the description box of our YouTube live. So,
if there is any question, I will be more than happy to entertain them.
yeah, basically this is live on YouTube. So the questions will be posted bit later, sir. So I will try to provide the email ID of yours on the description. So if anyone has any question, or they can just directly put in the chat box there. Okay, so I would like to thank all the participants who were live here from Facebook Live and YouTube Live. And also thank you so much, Mr. Amit Kumar Bharadwaj, sir, for taking out the time. We really appreciate your time. Thank you so much, and have a good time, sir.